Welcome, everyone, to Gresham Chapel here at Woodward Academy. I am your anchor and your host, Brian Keith Jackson. Today, you will observe a simulated Supreme Court experience. We have several cases on the docket today and for the next several days, which will be argued by students in my government economics class. Here is how it's going to work. Students from our government econ class have spent the last 3 months writing and researching current Supreme Court cases. These students have been assisted by Woodward Academy debate team coaches, Miss Maggie Berthume, here on my left, and Mr. Bill Batterman, here on my right. They've been further assisted by senior varsity debate members Alex Dunner, Sahil Patel, Zoe Rosado, James Walker, and Karthik Srinivasan. The students will play the role of lawyers using skills they have honed over the past 3 months. The students in my class will take their shot at trying to convince the student judges, the gallery audience who is here in Gresham Chapel today, and our digital audience, you at home, who are watching on WA Live via the internet, that their side should win. Following the oral arguments in the Supreme Court, we will cut away from the courtroom back to our studio here at Woodward Academy Live Court TV version. Following color commentary by our resident experts in the studio, and a few guests to be revealed later, we will engage in a little audience participation. Audience participation will occur in a variety of ways. Audience member here in Gresham Chapel will be able to vote via their personal device which attorney they believe did a better job, which side they predict the Supreme Court will rule, etc. All right, we also have a popular vote, all right, deciding who they think should and will win the case. All right, our digital audience, you at home, will also be able to participate. You may chat with me online real time by using todaysmeet.com. The actual URL address is http://todaysmeet.com/BKJ for Brian Keith Jackson. Now, students from Mr. Broad's video class and my governor class will play the role of the judges, and they will render their verdict following the oral arguments by the individual students. We have 2 cases on the docket today. The first case is called Evans versus Michigan. The second case is called Bailey versus the United States. Ordinarily, there'd be a break in between these cases, but for time purposes, what we're going to do is that we are going to hear both these cases at the same time. These are real cases, everyone. They are currently before the United States Supreme Court. No one knows exactly how the court will actually rule. So, without further ado, let's kick off the Supreme Court Week and Black History Month here at Woodward Academy for this particular period. I hope you enjoyed the arguments and you learned something along the way. All right, now, let's first talk about the case of Evans versus Michigan. Mr. Batterman, as a former government attorney, U.S. attorney, handicap this case for us. Tell us what we're likely to hear during this particular case.
Well, Evans v. Michigan is an interesting case that deals with the issue of double jeopardy, or the ability of criminals to only be tried once, or accused people to only be tried once of the same crime. And Evans v. Michigan, an individual was accused of arson, and the judge mistakenly decided that in order to meet the burden of proving arson, that the building that the person burned down had to be occupied, which is not true and was a mistake on the judge's part. So during the middle of the trial, the judge issued a directed verdict finding the person not guilty, and the government is seeking to retry the individual for that arson crime because the judge had made a mistake. The government's argument is that the mistake in this case is different than a mistake in other cases. Normally, double jeopardy doesn't apply because the facts of the case have been deliberated on by the jury, and so the facts of the case are what is at issue. In this case, it's a technicality and a mistake by the judge. So the government is seeking to retry Evans on arson grounds to make up for the mistake made by the judge.
All right, very good. I think that hopefully the audience has a good handle on the Evans versus Michigan case. All right, now I'm going to turn to Ms. Bethune. Ms. Bethune, you are a former ACLU attorney. Tell us a little bit about what you think about the Bailey versus the United States case.
Yeah, the Bailey versus the United States case is about detentions during searches. In 1981, the Supreme Court ruled in Michigan v. Summers on a 6-3 decision that there is a limited ability to detain suspects while a search is going on. So if I arrive at a home and a search is going on, the police may detain the people at that home. Mm-hmm. This case today, Bailey versus the United States, discusses the scope of that and whether defendants or possible suspects can be detained away from the home during that search. So in this case, Bailey was detained away from his home, did not know the search was going on. And so we believe that that the case should be thrown out, that Bailey should be determined to be released because he was illegally detained, which violated his Fourth Amendment rights.
All right, well, you know what? We will see what the Supreme Court says about this, as we will hear both cases, Evans versus Michigan and Bailey versus the United States. All right, now, I think I hear the U.S. Supreme Court coming, so without further ado, we'll turn it over to the actual Supreme Court courtroom, and we'll hear the arguments.
United States Supreme Court justices presiding. The two cases on the docket today are Evans v. Michigan and Bailey v. United States of America.
Is the attorney for the plaintiff ready to proceed? Is the attorney for the defense ready to proceed? Yes. Attorney for the plaintiff, you may approach the podium. You have the court's attention.
Hello, my name is Grace Brown, and I will be representing Michigan in the Evans versus Michigan case. On September 2008, Detroit police officers saw Lamar Evans running away from the side of a burning house while carrying a gas can. The officers commanded Evans to stop running, but he did not listen. The officers had to chase Evans on foot. Once they caught him, Evans was told the officers that the burning down the house was a mistake. The house was vacant, and someone was in the process of buying it and moving their stuff in. There were burn patterns throughout the house, and with testing, it was confirmed that the gasoline had been poured throughout the rooms of the house. Arson investigators said that it was definitely arson and said that Evans poured gasoline in 3 rooms. He was charged with willfully or maliciously burning any building or other real property. Evans was charged with violating Section 73 of the Michigan Penal Code. This says that the building does not have to be a dwelling to be charged with the lesser arson. The lesser arson would just be any building. Any building or property that you burn is 10 years in prison. Evans' lawyers said that the building was not a dwelling house. Michigan failed to prove that the building was not a dwelling, but they were not charging him with a higher punishment. For 20 years, you must prove that the building was a dwelling. For 10 years...
Excuse me, does someone have to live there for 20 years?
No. You just... A dwelling just has to be someone living in it, and they didn't have to prove that it was a dwelling.
Does a dwelling, does the person living in the dwelling have to be living there permanently or temporarily, or is it both?
It just be someone has to be living in the house for it to be a dwelling. So for 10 years, it just has to be any building. Evans burned down a building, and they were going to prosecute him for 10 years in jail. The judge told Michigan that they needed to prove that the building was not a dwelling. Michigan did not need to prove the house was not a dwelling because they were only charging him with lesser arson. Michigan wanted to go pull the statute, section 750.73 of the Michigan Penal Code, but the judge did not allow them to retrieve the statute. The judge ignored any of the evidence Michigan offered that proved elements that were relevant to the case. The judge gave the acquittal to Evans. So the issue is whether the double jeopardy clause will prevent the state of Michigan from retrying Lamar Evans when a directed verdict of acquittal was based on the government's failure to present evidence of a non-existent element of the charged offense. They did not have to prove that the house was not a dwelling. The double jeopardy clause of the Fifth Amendment of the United States Constitution says that no person shall be subject for the same offense to be twice put in jeopardy for life or limb. This clause is to prevent the government from continually trying to convict someone for a crime. For double jeopardy purposes, the acquittal must represent a resolution of some or all of the factual elements of the offense charged. In this case, it's not double jeopardy because nothing was decided about any of the elements of the case under law. The judge gave an acquittal that had nothing to do with his guilt or innocence. They never decided whether he was guilty or innocent. The trial never even got this far. And so the trial judge added an element that was not needed, and Michigan was not required to prove the element the judge was requesting. So the judge totally messed up on his end. In conclusion, it should not be double jeopardy because none of the underlying facts of the defense were heard. The judge had Lamar Evans win even though his guilt or innocence had not been proven. The ruling should resolve at least one of the things charged against Evans. No factual elements of the charged offense were even reviewed. Giving the defendant double jeopardy protection for the failure of the judge will not be granting the state a full opportunity to present its full case. Thank you.
Is the attorney for the defense ready to proceed? You have the court's attention.
On September 22, 2008, 2 Detroit police officers witnessed Evans running away from a house that was on fire. Once they saw that, they investigated and began chasing. Evans had a gasoline can with him. One of the officers commanded Evans to stop, but began to chase anyway. Once seized, Evans then informed the officers that he had made a mistake in burning down the house. The state of Michigan charged Evans with the burning of other real property, and the burn patterns suggested arson. The Michigan trial court required that the state of Michigan prove that the building was vacant, and when they failed to do so, Mr. Evans was granted acquittal.
Excuse me, was someone paying taxes on that property?
No.
Excuse me, would it still be considered arson if the building, so you're saying that it would be considered arson if the building was vacant, even if, what if there was someone temporary that was living in the house?
Yes.
Then it would be considered a dwelling, would it not?
Yes. The issue is that does the double jeopardy clause bar for retrial after the trial judge incorrectly holds a particular fact from the case to be an element of the offense and then grants a directed verdict of acquittal because the prosecution failed to prove that fact?
Who owned the property?
No, the property was a dwelling, so no one was owning it, but it was in the process of being owned, someone buying it.
From whom?
From the realtor.
So the house was active?
Yes. The double jeopardy clause of the Fifth Amendment states that no person shall be held to answer for a capital or crime unless presented or indicted for a grand jury. Ultimately, when it comes down to the law, Evans cannot be tried for the same crime once he was already acquitted the first time he was tried. In conclusion, Evans would like the court to vote that he is innocent.
Any Any questions, Justice Sotomayor? Would you like a rebuttal? Thank you, counselors. We are ready for the next case. Is the attorney for the plaintiff ready to proceed? Is the attorney for the defense ready to proceed? Attorney for the plaintiff, you may approach the podium and you have the court's attention.
On the evening of July 28, 2005, in Suffolk County, New York, police officers obtained a search warrant to search for a .38 caliber handgun in a basement apartment. Later that evening, officers sitting in an unmarked police car saw two men exit the basement apartment of the building. One of the men was the petitioner Bailey. The officers then pulled over the men and conducted a pat-down search of each man and found no weapons or contraband except for their keys to the basement. The men were then placed in handcuffs and were told that they're not being arrested, just detained while the search warrant was being executed. The men were brought back to the scene, and upon arriving at the scene, the officers had already entered the building and found some guns and a couple of grams of drugs. Both of the men were placed under arrest and taken to jail. A grand jury convicted Bailey of possessing cocaine, possessing a firearm, and carrying a firearm in relation to drug trafficking crime. The petitioner Bailey moved to show that he had been held in an invalid detention under the Fourth Amendment. The petitioner was found guilty of all counts and sentenced to 30 years in prison. On appeal, the petitioner stated that his detention was invalid under Summers, relying on the case of other circuits of that the district court discounted. The Court of Appeals reasoned that the officers acted as soon as possible in detaining the petitioner once he left the premises. The court concluded that the petitioner's detention did not violate the Fourth Amendment. The issue is whether or not the officers can detain an individual prior to the execution of a search warrant when the individual left the premises before the search warrant was executed. The petitioner Bailey claimed that his Fourth Amendment rights were being violated because the officers brought him back to the scene while the search warrant was being executed.
Which part of the Fourth Amendment? Is it privacy? Is it unjust searches?
Freedom from unjust searches and seizures. The issue in Bailey is whether in Summers v. Michigan, which allows police officers to detain a person or persons on the premises in order to execute a search warrant, extends to let the police officers detain someone leaving the premises. The police stopped the car but also searched them and found the keys that opened the door that they just left. Hold on. At the trial, Bailey was... hold on. The police officer... I'm sorry, I can't find what I'm looking for. Bailey was then arrested for the gun at the house. At trial, Bailey was convicted for possession of drugs. The suspicionless detention rule in Summers applies to anyone leaving the premises and creates a category of situations in which reasonable suspicion is automatically assumed to exist. Also, if someone is posing a potential threat to the police, it is unlikely that the individual will help the police execute the warrant and try to prevent the officers from executing the search warrant. But on the other hand, if the individual is assisting the police while they execute the search warrant, it is unlikely that they will pose a danger and not need to be detained by the police officers. Furthermore, there is no evidence that the police officers abused the rule of Summers or behavior that law enforcement viewed the rule of Summers as an entitlement to search freely. The courts will rule that if a person is leaving the vicinity of the property prior to the execution of the warrant, then the officers have the right to detain the individual prior to the execution of the warrant because they could not pose a threat to the police officers and try to prevent the execution of the search warrant. The court should also not change the rule of Summers that allows police officers to detain persons on the property prior to the search warrant being executed, because the officers will be suspicious of any persons on the property that they are about to search.
Okay, the attorney for the defense, you may approach the podium, please. And you have the court's attention.
Okay. On July 28, 2005, a New York City police officer received a search warrant to search the basement apartment for drugs based upon information the officer had obtained from a confidential informant. The police officer saw Mr. Bailey leaving the premises with another man from his basement apartment through video surveillance. The officer followed Mr. Bailey's car and stopped him 1.1 miles away from the original place that the warrant specified, which was the basement apartment. Police officers returned Mr. Bailey back to his apartment. There, the police conducted a search in accordance to the warrant and discovered weapons and illegal drugs, which was cocaine. The United States...
Wait, we have a question.
Oh.
Okay, so did they search the basement while the other police were driving behind him?
Well, to clarify, Mr. Bailey drove and the officers followed and pulled him over 1.1 miles away from the specified place in which the warrant showed to be searched. And where I was going, they searched his car without a warrant and found keys to the basement apartment.
And then they came back to the premises that was...
Yes, they detained Mr. Bailey and they brought him back to the premises in which the warrant specified, used the keys in which they illegally obtained from the vehicle that they searched 1.1 miles away from the specified place in which the warrant stated.
And who had custody of the warrant?
I'm sorry?
Who had custody of the warrant?
The police officer in which detained the individual, Mr. Bailey.
Was the basement searched before the police officers pursued the man?
No, they used the keys found in the vehicle 1.1 miles away from the... and they detained Mr. Bailey away from the vicinity of the search warrant, brought him back in handcuffs, then used the keys they found, opened the door to the basement apartment.
Where were the keys specifically?
The keys were in the drink holder of the vehicle.
So in plain view?
I'm sorry?
In plain view?
Yes.
So there was not a warrant to search the car?
No, there was only a warrant to search the basement apartment. May I continue?
Yes, you may.
Okay. So they used the keys to unlock the basement apartment in which the warrant has specified. They then found cocaine and 9mm pistol.
What was the warrant looking for?
The warrant was in suspicion of drugs.
But no firearms?
No.
Okay. How was the warrant? Like, were you guys given a tip? Or, why was the warrant obtained in the first place?
There was suspicion that my client, Mr. Bailey, had possession of drugs.
Was that just an anonymous tip, or?
Yes. Okay, so the issue here is whether the officers can detain an individual prior to the execution of a search warrant when the individual in suspect leaves the premises of the specified place of the warrant. In the case Michigan versus Summers, the same situation occurred in that Mr. Summers was detained while police executed a search warrant and found narcotics in the basement. The difference is Mr. Summers was detained on the premises and in the vicinity of the search warrant. Here Mr. Bailey was detained a mile away from it. And so also an issue and an argument here is whether police tried to go get Mr. Bailey and return him or to supposedly keep him in the vicinity of the search warrant so they could execute that.
Where was he detained?
He was detained a mile away from the search warrant after he had driven off.
Was he detained in a jail cell or what?
No, he was handcuffed but not arrested and then brought back to the specified place in which the warrant stated. And
so he wasn't detained a mile away. He was obtained a mile away.
Yes, ma'am.
Did you say that they can't execute the warrant without him being on the premises?
No, they can, but the only issue is that arresting Mr. Bailey by bringing any individual back to the place in which there are illegal possessions such as cocaine or the 9mm in this instance would automatically make any individual guilty or just for arrest.
But didn't Mr. Bailey already leave the place where they brought him back?
Yes, he had already driven a mile. As the police followed him, he had no information that they were following him. They then pulled him over a mile away from the vicinity of the search warrant.
So do you believe that he was wrongfully detained?
Yes. So the rule...
Bell rang. We've got to go.